In re Professional Financial Investors, Inc., Thomas P. Kelly III appearing for appellants, Christopher C. Sullivan appearing for appellee.
Hey, good morning or afternoon, I should say. Mr. Kelly, you want to reserve some time?
Yes, please, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay. Please go ahead.
Thank you, Your Honors. May it please the court, Thomas P. Kelly III appearing on behalf of Richard and Kathy McAvoy, the appellants in the matter. We're here today to present an appeal on the motion for summary judgment granted by the bankruptcy court. On the basis that we appear is because the ruling was based on inadmissible evidence. That's our chief objection, and also that there's a triable issue of material fact regarding the source of the funds. I want to stress to the panel that the only supporting evidence that was presented in support of the motion for summary judgment was a declaration by counsel. I'm referring to it as the Sullivan Declaration.
Let me interrupt you and ask you a question. Rule 7056C, I think it's C, says that you can oppose a motion for summary judgment on the grounds that the supporting evidence could not be presented in an admissible form at trial. Are you saying that there's no way that these reports could be presented in an admissible form at trial?
Well, no. For example, the people that authored because remember, there's the Sullivan Declaration, and then there's the Herrera Declaration that's part of it. Ms. Herrera could appear as a witness and authenticate all the documents. She also could have submitted a declaration in support of the motion for summary judgment, but did not. Instead, what we have is an incomplete copy of that declaration that's attached to
but I guess what I'm driving at is the trustee could have had an FTI person testify at trial to authenticate the report. So that report could have been presented in an admissible form at trial.
Well,
right?
Could have is a much different question than was presented, Judge. And the reason why is, look, in cases like this, I'm always worried about everyone looking forward to the end result without going through, the proper steps. And that's really why I'm here, is because I don't think those proper steps were followed. And just as a matter of humor, in my office, I have a crystal ball with an out of order sign on it, and I got it right here. Okay. And the reason why is because there's a temptation to jump ahead in the steps and reach a conclusion.
Isn't that temptation mitigated here, where you relied upon the same information after authenticating it through the trustee?
Okay. We did not rely on the same information. We presented them as exhibits in support of our argument to say, this is what the trustee is claiming in this case. And say, so here's their.
But you presented it that not only that was the evidence being used to establish that, as detailed through the deposition of the trustee to explain how FTI came to have those, including the actual entries as to the time for each transaction, and then aggregated into the 4 accounts. And
correct, Judge. I was analyzing their claims and setting forth that information. And that's where we get into the account 100195, if I have the number correct, where there is literally this $215,000 that just pops into existence with no account history whatsoever. And we're saying, like, wait a minute, where did that come from? Is that?
Well, it did have an account history. I mean, there was only like 4 or 5 transactions, granted, but there was 2,000 in, and then 50,000 paid, 2,000 paid, 200,000. I'm sorry, 200,000 paid. So there was a transaction history.
Well, correct. A very brief one, Judge. And the reason it's so brief is because there's the artificial cutoff of when the UVTA and clawback statute of limitations run. I'm sorry. Did somebody ask me a question there? Sorry.
I think it was Echo.
Okay. But the reason that that's significant is because my clients had an account with this firm for years before that date. And there was contributions made by them, which we are attempting to present. And that's where the source of those funds. So what we're saying is, wait a minute, where did this money come from? It's all being treated as if it was profits or net profits, without reducing the total contributions of my clients. And we allege that.
I don't think that is what they did at all. I mean, they tried, under Donnell, they tried to figure out how much was put in and how much came out and when that came out. And they limited it to those amounts that came out in excess of what went in within the 7-year statute of limitations.
Correct. It's that narrow time frame. which is an artificial frame because there were transactions prior to that.
But that was captured by the beginning balance, wasn't it?
We don't believe so, no.
But the point, to get back to your crystal ball, is that you don't. Your argument is that the beginning balance wasn't the beginning balance because there was no authentication, despite what appears to be the authentication in your second summary judgment. Where is the evidence to actually dispute that fact?
Well, our position is that insufficient evidence was presented to sustain motion for summary judgment on this record because the Sullivan Declaration was subject to multiple valid evidentiary objections. Specifically, those were, under 56, FRCP 56, it has to be supported by a declarant who has personal knowledge of the facts.
And set out facts that would be admissible in evidence and show that the affiant or declarant is competent to testify on the matter stated.
Right.
I think I heard you agree that these facts could be admitted. I mean, that could be presented in an admissible fashion.
But could be admitted is not the same as presenting an admissible record for a motion for summary judgment. Because
I think that's what Judge Ferris was getting at.
Okay, well, what I'm trying to point out is first, Mr. Sullivan's position is being presented as if he's an expert, and he's not under 701. Also, there's hearsay statements about what the financial firms were doing in terms of how they processed this information, what records they used, and everything else. And that is, again, hearsay under 802. And what we've got here is, and then incredibly, the trial court held that the two different declarations, the one that was used earlier in the case, is identical to the one that was presented in response to this motion for summary judgment, and then held that we waived our objections on that basis. They're not identical. I specifically run through the very serious and material differences between the two. For example, there's a series of claims regarding what FTI Consulting, that is the trustees' appointed financial advisors, and I'm quoting it right now, this is Appellant's Experts of the Record 23, it's page 175, that they created investor claim packages detailing all investments associated with particular tax ID or social security numbers. That's a statement of what someone else somewhere else did. Now, could it be admissible at trial? I don't really know the answer to that because I don't know where that information is coming from. That's coming from Mr. Sullivan.
So, counsel, let me ask you a question. You're disputing that they started at the right point with an amount of money that was in excess of $900,000 as the original investment. Over the period, they calculated returns in excess of $1.3 million, somewhere around $1.4 million, so that the total liability was $400,000. And then they took and clawed back or reduced that amount by only those amounts that were within the period of 7 years. If they were outside, they were just not returnable to the debtor end. Tell me how your clients were damaged by the admission of the declaration that said that they invested $900,000 and some thousand in the beginning and then went through the calculations that resulted in a total amount of damages in excess of $400,000. Is that not accurate?
Well, first of all, Judge, the summary judgment as ordered is based on that evidence. Okay, so summary judgment has been entered against us on the basis of a declaration that has multiple evidentiary problems. On top of that, the underlying documents that are there are not properly authenticated by the Sullivan Declaration. It's a technical point, I agree, but I'm trying to point out is that the technical specifics that are in there matter a lot, and they're not the same declaration, and we didn't waive any objections. They're stated in my opposition brief to the second motion for summary judgment. And in addition, they entered additional evidence in their reply brief, which I objected to, and the trial court wouldn't listen to us. They struck my objection brief as not being authorized. I restated the objections at the hearing. Those objections were all overruled on the basis of waiver. We didn't waive anything. And that's the problem we have here. Is my understanding of a summary judgment is that it is this very precise, very specific procedure that has very clear elements that must be met. And that evidence has to meet the standards set forth by FRCP 56. In this instance,
So your objection is not that the information contained in the report and the calculations aren't accurate. Your argument is there's not enough sufficient evidentiary support for those calculations to be admitted against us in summary judgment. We don't dispute that we received more money than we were entitled to. We don't dispute that we were net winners. We don't dispute that we owe money back to the estate. What we dispute is you haven't proven it with the specificity required by the motion for summary judgment requirements. Otherwise, the evidence is accurate.
well, no, I do not concede that it's accurate. Okay? No. What I would say, though, is that it's twofold. That first, if the evidence was presented properly, then it would be a different picture. But we dispute the foundation as to what amount of money was in there at the start and the reasons why.
But you don't. If it was less, you would owe more.
Well,
if it was less money, you would owe more. Only if it was more money, and you don't have any evidence that it was more than 900,000, whatever the number was in the beginning, do you?
Well, Judge, sort of, but we never reached that point. And I just want to point out, we're talking about evidence. And that's what I'm really here about is on a summary judgment motion, there must be, there's no tribal issue of material fact and the moving party is entitled to judgment as a matter of law. In this instance, on this record, I don't believe it meets the standard under motion for summary judgment because we timely objected and I believe those objections are valid and the trial court didn't rule on them. And that's the first.
You've got about 4 minutes left if you want to reserve your.
I'll reserve the rest of my time. Thank you very much, judges.
Okay. Mr. Sullivan, please go ahead.
Good afternoon, Your Honors. Chris Sullivan, Blackburn, and Pratt on behalf of the trustee, Michael Goldberg. It's always an honor to appear before the bankruptcy appellate panel, but I'm struggling a bit to find something useful to say because I think the court understands the issues and I hope we briefed them well. I will say that Judge Spraker did touch on a point that I was going to mention, but he stole my thunder, and that's the question of personal knowledge and what it means in this context, as well as the evidence being not admissible per se, but there has to be showing that it wouldn't be admissible. I mean, I think when you talk about lawyers who are preparing declarations about certain facts, I did have personal knowledge of what FTI did, and I did have personal knowledge of the general nature of how they went about it. But if the standard is you have to be sitting in the room watching what they do when they do it in order for it to be admissible, that's just flat wrong.
Well, I think the bigger point, and this is more of a comment than a question, is that if you'd had a declaration from the author of the report, an FTI report, we either wouldn't be here or we'd be having a very different argument, right?
Well, no, I think we'd be here, but that's another story. But
so
we did.
We'd be having a different argument, right?
Yes, but we did, as you know, and it's not Ms. Herrera, it's Ms. Herman. I mean, we did have the declaration. I mean, she did submit a declaration. It was in the prior motion which the judge followed. So, no, we did. I mean, it's just undisputed. And I was shocked a little bit, in a sense, to see Mr. Kelly say in his reply that the trustee authenticated, the documents because he did. And that's the whole point, other than, reaching out for these various threads to try to make some kind of an argument, and in terms of whether we should have had, Ms. Herman's declaration, sure. But I mean, there's a million ways, especially in bankruptcy courts, that things could go wrong, And I have a Navajo blanket story, which is like the Navajo tribes made very, very intricate blankets, but they would always have one mistake in them. And that was because they thought to do everything perfectly was to impermissibly imitate God. And I just think we had a rock solid showing. There's no doubt about the outcome. And I don't, love to answer more questions, but.
Any questions from the panel for Mr. Sullivan? Okay, apparently not. Thank you very much. Back to you, Mr. Kelly. You've got, I think, about 4 minutes or so, a little under 4 minutes. Please go ahead.
Thank you, judges. First, I think my crystal ball story was better than his Navajo rug story. So I just want everyone to take judicial notice of that. Thank you very much. And if it's true of the Navajo, it's also true of the Persians, the so-called Persian flaw for the rugs. But anyway, the reason I continue to emphasize a motion for summary judgment, and my understanding, is a highly technical procedure, and you have to meet very specific requirements for the evidence to support it. And we robustly objected to the way that evidence was presented. And what I was confronted with was Judge Blumenstiel held that we had waived a lot of these objections on the basis that these declarations were identical. I could run you through the specific instances where they're not the same, but I put it in the brief in a condensed format saying, here's where this provision is, and it doesn't appear in the second one. And I think Mr. Sullivan kind of hit the point there. He says, like we know how this is going to come out. We know how this case is going to end up. And you can't do that on summary judgment. Now, whether or not I don't believe the evidence is sufficient as presented, and that the objection should have been sustained. And as a result, maybe we're back here on another motion for summary judgment. And, again, we have a different argument, as you pointed out. But the position we've taken is that there is a triable issue of material fact regarding the source of the funds. Now, whether the court feels that's persuasive or not is one thing. But the objections to the evidence that's presented, those have a robust argument behind them. And overlooking the flaws with the declaration and supporting evidence is the thing you're really not supposed to do in a motion for summary judgment. It's the burden on the moving party to present the evidence. And the only evidence presented was a declaration of counsel. There was no request for judicial notice. There were no other exhibits. There was nothing. It's just that. And if that declaration doesn't meet the standard of FRCP 56, the motion for summary judgment shouldn't have been granted. Okay. And with that
gets you back to your objection to their reply and the use of the deposition of Mr. Goldberg, right?
Correct, which was, again, we had no notice of. It was presented for the first time in the reply brief. I objected to that, filed an objection. The court struck it as not authorized, and then restated the same objections at oral argument. So it's in the record. And that's why, I'm very worried that they got a summary judgment motion on this record, because I wouldn't have, anyway, I think I should probably leave it there. Because the thing is, I don't see the evidence as presented as being sufficient to sustain a motion for summary judgment under my understanding of how that works. This is a procedural argument. It's an evidentiary argument. It's relying on the rules of federal rules of evidence, which should be applied here. But for whatever reason, the trial court elected not to do that. But the waiver argument is wrong.
To cut to the chase, I think part of the problem largely is in reading your second motion for summary judgment and relying upon Mr. Goldberg's deposition, you use FTI. Now, it's the use that's at issue here. Because you're saying, as I understand your argument, we just said what he was going to say. We didn't say that what he said was valid. And yet there does not seem to be that limitation on the FTI report in your second summary judgment, such that the court understood that when you raised it, and when the court ruled on that second summary judgment, it ruled as to the numbers and the calculations based upon that. And I think that was the due process that was given, right? Well, because the court's saying, I am reading what you offered, and that says, based upon the calculations that Judge Gann was alluding to, net in, net out, that's it. Those are the numbers.
But we did not concede the accuracy of them. And by the way, I'm over my time.
I think that's the question.
Oh, please go ahead and answer the question. You can certainly answer the question.
We did not concede the accuracy of it. I was putting those exhibits were placed in there to say, these are the claims of the trustee. And we are analyzing the evidence they presented because this is a motion for summary judgment, and then presented counter evidence and objections to the evidence as demonstrated. The problem with the reply brief is you can never put new evidence in on a reply brief because the other side
I don't think it was new.
Well,
because it had been raised before by you.
Well, portions of it had. but new stuff was the deposition is very broad ranging. And so again, you have the robes, I don't. I would leave that determination to you. Again, I would repeat Mr. Sullivan's statement in the start of his argument. It's always a pleasure to appear in front of you. It really is. You guys, you're probably one of the best courts I deal with. So thank you.
Thank you both. We'll flatter you guys back. Very interesting arguments. I learned things from these arguments I really didn't expect to learn about blankets and such. But the matter is submitted. Thank you very much.
Thank you, Your Honor.
Thank you.